All right. Okay, so at this point, I've heard all the evidence. I've heard the arguments of counsel. Ms. Benefield, this is addressed to you. Please feel free to consult with your attorneys before you answer, or if you want to answer. But at this point, I always just check with the defendant and say, okay, I've heard. Of course, there was a stack of letters that I got from your attorney as part of the downward departure. Heard Dr. Russell's testimony today, of course, presided over the entire trial. Heard the statements from the state as well. I always ask, though, is there anybody that I haven't heard from, any testimony I didn't hear, any evidence that I didn't hear, anything at all that I need to know to make a fair decision in this matter?
Your Honor, Ms. Benefield feels that I've spoken for her.
Excellent. All right. I also give a final statement, and I'm sure that you and your attorneys have talked about this at length. You are absolutely not required to make any statement. However, I also, whenever I have a trial case, we're doing sentencing, if it's an open plea, I do always give the defendant the last opportunity if there's any statements that you want to make. You're absolutely not required to. I'm sure you've already talked to your attorneys about it. But if there's any statement you want to make, please feel free to do so. If not, we'll just move on with sentencing.
I know the court won't interpret her choosing not to as a lack of invitation to remorse.
Fair enough. And as I said, you're not required to at all. All right, is there any legal reason why sentence cannot be imposed?
No, sir.
All right, so the first thing we need to do is talk about the bases that have been argued for downward departure. And I think today it's an absolute tragedy that we're even here today. And I often, in these situations, sit back and wonder, how did we get here? How did life bring us to this point, not only here in court, but between the Benefields? I think both sides have acknowledged, because both the defense, Mr. Taylor, and the state talked about lenses and perspectives. And I think this is a good example of exactly that, where whatever lens you view this case from can really affect how you view the players, the results, the participants, and the outcome. So we've got the score sheet to start from. The issue is whether a downward departure has been sufficiently, the burden of proving that has been sufficiently met, and then whether the court would grant a downward departure. So the bases are, and I'm going to just take them in alphabetical order from the statute, 921.0026 subsection 2. The first one is D. The defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, or for a physical disability, and the defendant is amenable to treatment. In that particular one, there was the testimony by Dr. Russell that she has diagnosed the defendant with PTSD. It's a complex trauma. She explained the genesis of it and how she reached that conclusion. But importantly, what needs to flow from that is a description of what that specialized treatment is, what sort of treatment is important or would be necessary to treat that PTSD, inpatient, outpatient, what kind of mental health therapies, and so forth. So based upon the competent substantial evidence that has been presented, I do not find that D has been proven by preponderance of the evidence, all the elements of D. F, the victim was an initiator, willing participant, aggressor, or provoker of the incident. The reason I asked that question and I was looking around is I had a case and I thought I put it in my packet for today, but I'm not seeing it. There was actually a decision in the Florida Law Weekly within the past couple of months, it hasn't been too long ago, where that very issue was discussed. And the DCA in that case actually came down and said, when it talks about the incident, the evidence must support that the victim was an initiator, willing participant, aggressor, or provoker of the incident. And specifically said the court should not consider all of the pre-existing or attendant circumstances and just look at that incident. I think both sides took a great amount of time throughout this case to talk about incidents and events and happenings that occurred before September 27th of 2020. Do I have the date right? September 27th of 2020? But I think the case law talks about that particular day or that particular event. And it doesn't need to be, for this downward departure basis, the law is very clear. The defense doesn't have to prove it by clear and convincing evidence beyond a reasonable doubt. They don't have to prove or provide evidence that is beyond a reasonable doubt. The question is there competent and substantial evidence that in the incident itself, the victim was an initiator, willing participant, aggressor, or provoker of the incident? And quite frankly, the evidence, the preponderance of the evidence has established that Ms. Benefield's testimony is sufficient in and of itself. And I understand the state is arguing that to discount her credibility, but is there evidence in the record that proves by a preponderance that Doug Benefield was an initiator, willing participant, aggressor, or provoker of the incident? And there is. That was the entire basis of the sentence.
The Honorable Matt White there laying out why he is going to sentence Ashley Benefield the way that he will. That's coming up soon. Let's bring in our guest for this hour who is discussing this case with us. Los Angeles, California is where she is. Criminal defense attorney and former prosecutor Marie Pereira. Marie, you heard the judge say that he is going to focus on the incident and not necessarily the pre-existing days. Your thoughts on whether or not he does need that context to take into consideration for this sentence?
Actually, he doesn't need the context. And this was more not like a downward departure request from the defense. It was him using big words to curse out the judge. And I really don't think he did his client any service with that. He's basically starting it out with all due respect, respectfully, and saying from the beginning, when we had the stand your ground hearing, judge, you messed it up for us because you made improper rulings. You were almost biased, and it's your fault this happened. It was almost like watching Sarah Boone, but like a lawyer, with her statement to the court yesterday. I just don't understand why he did that, the defense attorney, but the judge is not going to be swayed, and he really insulted the judge, and it's inappropriate the way he handled this request, and down departure is going to go up because of what he did, I believe.
Marie's saying the exact same thing I said when I heard him speaking. It's like, it sounds like he's doing exactly what Sarah Boone did, ignoring the fact that the judge already did an order denying a motion for a new trial.
Yeah, but I kind of like his fight. Like he gave it his all during trial. We watched this trial play out, and he's just really upset by this jury's decision, and he blames the judge for a lot of, I mean, let's face it, the judge did side with the prosecution 99.9% of the time, which is nothing new in the courtroom, but I like the fact that he's fighting, and he's mad to the very end, and he's fighting for his client here, and I hope, because the judge did say something, Marie, that I actually felt good about. He said, I'm not in this chair if I can't take the arrows, basically the slings and arrows. I like that because he addressed it. He addressed the fact that, dude, you're coming at me like a pit bull, or I'm about to sentence your client. And he made that statement, which I like. So I'm not convinced that he's going to take this personally and take it out on his client, but it's something else to watch.
You know what? Under the robe, he's a human being just like me and you. And he could say big words like, I have good temperament, I'm a judge, I'm neutral, but that guy disrespected him. And it wasn't just, with the outcome. He made it sound like the judge didn't know what he was talking about when he was making rulings concerning key evidence in him presenting his case. That's a whole different thing. And he could use the word respectfully, but that was disrespectful, and the judge is going to come down on him for that, because under the robe, there's a person with a heart, and that was uncalled for.
And after this break, we are going to hear what the judge decides for Ashley Benefield. Stay with us. You're watching Court TV.
Tonight on Court TV.
I'm Vinny Politan. Welcome to Closing Arguments. We have a big hour ahead here.
Your deplorable actions are unforgivable.
The community still doesn't know how this Boston police officer died.
He can't prove one element of his case.
It was a dramatic day, a dramatic moment inside the courtroom.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan. Tonight at 8/7 Central. Only on Court TV.
Welcome back. Let's get you back inside of the Florida courtroom we are following for the sentencing hearing for Ashley Benefield. You'll remember a jury found her guilty of manslaughter in the July 2020 death of her estranged husband, Doug Benefield. But the jury didn't believe the former ballerina when she claimed that she shot her husband in self-defense.
Let's go back into the courtroom now. We're going to pick it up right where we left off with the judge speaking to the parties.
Self-defense argument. So I do find that the requirements of F have been met. G, the defendant acted under extreme duress or under the domination of another person. This is why I was asking about the case law, because I have not seen this particular statutory basis applied in this particular factual scenario, where it's argued that the defendant acted under the extreme duress of the victim as a self-defense matter. But just because I haven't seen the case law doesn't mean that it doesn't exist and it can't be argued for those or that purpose. So for the purposes of today, using a similar analysis as I did under F, but also considering the past relationship between the parties, I think there has been competent and substantial evidence to establish by a preponderance that the defendant acted under extreme duress. The domination of another person, I just don't think fits. So to the extent that that particular downward departure basis requires that the duress comes from a conspirator, a co-conspirator, a confederate, or a principal, I could be wrong, but I think it applies, and I'm applying it here. Or I think it's been proven. And then J was the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. The case that I talked about a few minutes ago regarding victim was an initiator, willing participant, aggressor, or provoker of the incident, J has similar language. The offense was committed in a sophisticated manner. So I understand the state's argument saying, hey, this was a whole series of events and was very sophisticated in its planning and execution. At the end of the day, the statute itself says the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. So if I look at just the incident itself, there's nothing sophisticated necessarily about self-defense and using self-defense. Isolated incident, the defense has pointed out, and the score sheet shows there are no prior acts of violence, there's no prior convictions. The case law requires, though, that all three elements of this be established. The final one is the defendant has shown remorse. Obviously, she's exercised a very, very fundamental constitutional right by not making a statement today. But I can also, I believe, consider the testimony that was provided during the trial. And remorse is not necessarily and doesn't have to be I'm sorry I did this. Because someone is perfectly entitled to maintain their innocence even in light of a verdict of guilty by a jury. So I find that during the trial itself, that Ms. Benefield did demonstrate remorse for this entire incident happening and the culmination and the resulting death of Mr. Benefield. So I do find that J has been established. The non-statutory bases, there were none explicitly argued, but I'm going to make a ruling on the individual and culmination of errors for appellate purposes. Again, I'm not aware of any case law that establishes that. To the extent that there's an argument to be made that, and when I say individual errors, I'm talking about fundamental error, right? Because that could just be one thing and fundamentally vitiates the fairness of the entire trial. So individual or cumulative errors being the bases of a downward departure, I'm going to go ahead and make the finding that those are not, errors by the trial court are not bases for a downward departure, non-statutory bases. I may be wrong. We'll find out. The second part of the analysis is whether the court is going to exercise its discretion to depart. And that's where you really take into consideration those factors in determining, in light of all of the facts and evidence that have been presented, if this is a case that the court believes a downward departure should be granted. And as I said, I understand completely that two sides of this room are viewing this same case through very different lenses. As I consider all of the evidence that I talked about earlier that I reviewed in preparing for today, the jury's verdict, which they did not find Ms. Benefield guilty of the charged offense. It was a lesser included offense that did not include depraved mind. It included doing an act which resulted in the death of another person. I consider the score sheet and what Florida statute or chapter 921 discusses regarding the aim of sentencing, that being the primary purpose of sentencing is to punish, the secondary purpose is to rehabilitate. The PSI, which has been reviewed and considered, and I understand throughout the arguments that the defense has raised their disagreements. For what it's worth, the PSI in the factual part really just recreates or retypes the complaint affidavit. I don't really put a lot of weight on that. I don't need that because I presided over the entire trial. So I don't put a lot of weight on the factual recitation that was in the PSI. And as we all know, the PSI is not controlling on the court. The probation officer who does the report makes a recommendation, but unlike in juvenile court, where the Department of Juvenile Justice's recommendation is somewhat binding on the court, the DOC recommendation is not, but I did review that. And of course, as I said, I reviewed the defendant's sentencing memorandum, all of the various attachments, and listened to the statements that were made today from Dr. Russell, as well as David, Wes, Tommy, and Eva Benefield. And all I can say is thank you to everyone who took the time to write a letter and share your experiences. A number of them talked about that.
All right, judge is just about to deliver the sentence to Ashley Benefield. We'll get a break and then we'll hear the sentence. What do you think?
What will it be?
Well, we already know because we're a little bit behind.
We're a little bit behind.
We're not going to ruin it.
But we're going to watch it together.
All right, back after this.
There.
back to Court TV Live along with Julia Janae. I'm Ted Rollins. Glad to be with you. We're just about to hear what the judge is going to sentence Ashley Benefield, the retired ballerina found guilty for manslaughter. The maximum in this scenario is 30 years. What's the judge going to decide?
And before we get in for that sentence, let's give an opportunity to our criminal defense attorney who is standing by, Marie Pereira. Just to give your thoughts, Marie, what do you think we are going to hear from this judge?
I think the judge is going to be fair, Ted. I think he said, you know what, I'm looking at the totality of the circumstances and looking at the mitigators and aggravators, and she was remorseful. Remorse is a big element of being a mitigator, because to say you're remorseful means that there's a possibility for rehab. It was out of character for you, and I think the judge is able to keep the robe on and take the shots fired well and not hold it against her. Let's see what happens.
All right, let's watch. Here we go.
Coming up with Ms. Benefield, their interactions with her as they've grown up and growing into adulthood. Thank you for the statements regarding your relationships with Douglas Benefield and how his loss has impacted each of you. So when I look at the bases for the downward departure and I consider all of the facts and evidence that have been presented to me, my ultimate conclusion, Ms. Benefield, is that this is not a downward departure case. So with that said, the sentence of the court will be as follows. I'm going to sentence you to 20 years in Florida State Prison. That's to be followed by 10 years of probation. Upon your release, and the Florida State Prison was, of course, with all credit for time served, you must initially report to the Bradenton Department of Corrections. We'll be able to provide you a map of where that is. Cost of supervision will be a condition of supervision. Based upon the testimony of Dr. Russell today regarding you suffering from and being diagnosed with PTSD, the court is going to order as a condition of your probation that you obtain a mental health evaluation at your expense within 60 days of beginning your probation. You're to complete any recommended treatment, including residential treatment and aftercare if it's recommended, on the first attempt at your expense. You're to provide proof to your probation officer regarding the evaluation, participation in, and completion of that treatment. If it's necessary for your probation officer, you'll sign any waivers or releases that are necessary for them to get the information that they need or speak with your evaluators and treaters. I am going to order the forfeiture of the firearm in this matter, that being the Springfield .45, and I'm ordering that you have given up all rights, title, and interest to the same. I haven't heard anything about restitution at this point. I am going to order restitution. I'll reserve jurisdiction to determine the amount of restitution, the payee or payees, the payment schedule, if any, and other terms and conditions of restitution. I'm also going to reserve jurisdiction on the restitution to determine whether or not to waive or reduce the monthly cost of supervision and or the fees and surcharges that are associated. I'm going to impose the following monetary obligations: the felony adjudication of guilt court costs, $100 cost of prosecution.
$200.
Do you have an affidavit?
I don't have it with me.
I can look.
If you need one, we can get one.
It's required by Florida law.
Just, there's
If you want to
3,000
continue on,
pages.
we'll try and find it.
All right. If an affidavit is for cost of investigation is presented, I'll order $200 to the Marietta County Sheriff's Office. For now, I'm going to make all the legal financial obligations a condition of probation. All right, State, now that you've seen where I'm at with the sentencing, was there anything that you want to do, any further arguments, anything else you want me to consider?
Judge, my only concern would be the mental health evaluation. I would prefer that it not be with Barbara Russell when she's on probation and has to do the mental evaluation.
You don't want what?
You have ordered that the defendant do a mental health evaluation when she gets out on
Correct.
probation, and I would request that it be someone other than any of the doctors that were involved in this case. So not Barbara Russell or Dr. Quintal or Dr. Broder. Those-
Okay. I'm not going to order that. I'll let you pick your mental health professional that you want to see and consult with. Sir, now that I've told you where I'm at, was there anything that I need to explain or clarify?
No, sir. If you would, how long is the period of probation?
It was 10 years. Okay, Ms. Benefield, you have 30 days to appeal the judgment and sentence of, oh, yes, sir.
Make one statement for the record. I object for the record and argue it's an abuse of discretion based on the undisputed facts, not the granted downward departure.
Oh, yes, sir, absolutely. I think that's generally preserved no matter what, but
I do too, but
I appreciate your belt.
But the appellate courts like to find non-preservation, so I'm overly careful.
I understood. Belt and suspenders, no problem at all. Yes, sir. So objection to the abuse of discretion for not granting the downward departure. Noted. All right, Ms. Benefield, you have 30 days to appeal the judgment and sentence of the court. If you can't afford to hire a lawyer, one will be appointed to represent you. Oh, go ahead.
Sorry, I'll just have one thing.
Is it regarding appeal?
Regarding?
Appeal?
No.
Oh, well, go ahead then.
I was going to ask the court if the court would make arrangements to ensure that Ms. Benefield remains in Manatee County for at least 14 days, if not 30, so that we can tie up all the loose ends in preparation for the appeal.
Okay. I don't know how much pull I have over that. DOC comes gets people when they come get them.
Can I suggest that Your Honor set this for a report in perhaps 30 days?
All right, why don't you send me an order directing the sheriff to hold her pending any final hearings or matters? And I'll...
Judge, the most specific thing, we're going to be filing this motion for bond pending appeal, so that's why we're...
Oh, keep her there for that.
Yes, so to avoid the necessity of her going back and forth.
Absolutely. So do me a favor, contact Kelly, my JA, get that set. I didn't see it's been filed yet, but get it filed.
It has not, but I will file it tomorrow.
All right, get it filed. Talk with Kelly about getting a hearing date, and then I'll sign an order to hold her until after that date. Absolutely.
Thank you, Judge.
Thanks.
Of course. Okay, for the appellate purposes, what I was going to say is, ma'am, speak with your attorney. You can hire someone if you want, a private attorney for that. If ultimately you are going to seek the services of the public defender, I'll just need a financial affidavit and a motion to appoint. And then once Mr. Taylor completes all of his obligations as trial counsel, we'll get a local PD appointed and then the 10th Circuit PD. All right, ma'am. Thank you very much.
Final word from Judge White there. 20 years in prison for Ashley Benefield, 10 years after that serving probation, and they're doing some housekeeping and speaking about a new motion that's going to be filed by her team to try and get her released pending her appeal.
Which never usually works, but...
some cases.
Never known that. Yes, Neil Taylor is really going with it all, and you can see the defendant now being printed again as they prepare her for the transfer, which they're going to wait a few weeks. It sounds like the judge is open to that, to allow her to stay in Manatee County until before she's shipped off to the custody of the Department of Corrections in the state of Florida.
Yeah, that can mean the difference between being close to her family, her daughter, who's around 7 years old, versus going to a prison in some remote location.
Yeah, and that'll take some adjusting, obviously. Well, Marie Pereira, 20 years. What'd you think?
I'm surprised and I'm sad of the whole situation because there were no winners here. This was all about getting custody of her little girl for herself alone. Now the dad is dead, she's going to prison, and the little girl is just without parents. So who's the winner here? And I think these sentences and these verdicts are sending a message. Battered spouse syndrome is not a free carte blanche to go out and murder someone, even though that person abused you and it was documented in the past. Timing is everything. There's a law and you can't just exact vengeance against your abuser. This is what I'm getting from Sarah Boone, because at the end of the day, not to victim shame, but these men did abuse those women. And still, It's the timing. You can't do it after the fact to say, I'm killing you because of what you did to me.
Yeah,
but it's just really
so far
sad.
here on Court TV that we've seen recently this year. Marsha Thompson was the one case where battered spouse syndrome worked as a defense, but the fact patterns are different in each one. What do you think was the downfall here, Marie? Because I think you pointed out really well to point out that this judge mentioned he did see remorse. Even though she didn't make a statement at sentencing, he harkened back to what she did on the stand during the trial and what we saw in that emotional response to saying what happened. He did see remorse. Judges don't often acknowledge true remorse in a defendant.
He saw remorse, but at the end of the day, the judge is somebody who is a judge and he adheres to the law. And her claim that she was afraid of him, she was a battered spouse person suffering from victimization and trauma, didn't really jive with him because the judge was there just like us. And the judge understands she lured him back to the house. And then it happened. And she made her mom and child leave the house. And no one was there when it happened. So, and the judge knew that she had something against him. And after the fact, she chose to do that, and he ended up dead. So I guess the judge looked at the totality of the circumstances and sent a message. Leave it up to the law. You can't go around killing people after the fact for what they did to you.
Right. Yeah, no, it's a tough one, and I agree with you, Marie. This is just everyone's a loser here. Doug Benefield was, you know, he abused their dog. He put a tracker on her car. He shot a pistol in their house, and you know this is all documented. He admitted to abusing her under oath. It was another one of these complicated cases, and at the end of the day, no matter what you think about Ashley Benefield and her performance on that witness stand, it is to Marie's point, just a sad, sad case.